My name is Thomas Alexander. I am the President of the South Carolina Senate. Due to population shifts in South Carolina's Districts 1 and 6, our Senate was tasked with redrawing our state's congressional district maps following the 2020 census. This process was guided by traditional districting principles and the goal of creating a stronger Republican tilt in District 1.
My name is Brenda Murphy. I am the President of the South Carolina State Conference of the NAACP. South Carolina's new districting plan resulted in an unconstitutional racial gerrymander and diluted the electoral power of South Carolina's black voters because it relied predominantly on racial data in deciding which residents to move into which districts.
No, this was a constitutional partisan gerrymander, not a racial gerrymander.
I'll be the judge of that. The question we will rule on today is whether the South Carolina legislature's redistricting map, which moves tens of thousands of black voters to a different district, constitutes an impermissible racial gerrymander, even if the legislators' purported intent was merely a political gerrymander. And our answer is no.
I concur.
We dissent.
What? How did you make that decision?
We review the district court's factual findings for clear error, meaning we may not set those findings aside unless we are left with the definite and firm conviction that a mistake has been committed. We find that the district court did commit clear factual error in concluding that race played a predominant role in South Carolina's new districting plan, because the challengers of the map did not prove that traditional race-neutral districting principles were subordinated to racial considerations. Instead, they relied on deeply flawed expert reports and did not offer a single alternative map with a higher BVAP in District 1. That would have met the legislature's legitimate political goal of creating a greater Republican tilt in that district. In many cases such as this one, race and partisan preference are highly correlated, making it difficult to determine whether voters are impermissibly moved because they are black or permissibly moved because they are Democrats. We use two propositions to navigate this tension. First, we require challengers to show that race was the predominant factor behind the legislature's decision to move specific voters. Second, we start with a presumption that the legislature acted in good faith. To meet the first criterion, the challengers must disentangle race and politics by showing that race itself drove a district's lines. However, the challengers in this case did not produce an alternative map showing that a rational legislature sincerely driven by its professed partisan goals would have drawn a different map with greater racial balance. In fact, direct evidence in the record suggests that the legislature did not rely on race in the new districting plan, as the employee who drew the map testified to using only political data. In addition, all four of the challengers' experts provided flawed testimony, as they failed to consider various traditional districting principles and used inferior data.
I concur with everything except your analysis discrediting the experts' opinions. The analysis exceeds the proper scope of clear error review, which is not an invitation for the court to argue its own interpretations of facts. In addition, I believe the court has no power to decide the types of claims presented in this case. Racial gerrymandering and vote dilution claims are non-justiciable because they present political questions. There are no judicially manageable standards for resolving them. Instead, we must wade into the complex political issue of how legislatures draw congressional districting maps. In addition, the Constitution's Elections Clause commits the oversight of congressional districting exclusively to Congress, not to federal courts.
I dissent. According to precedent, our court must give significant deference to the district court's findings of fact when conducting clear error review. We must uphold them as long as they are plausible. However, the majority inverts this standard. Instead of giving deference to the district court, it defers to the losing legislature by presuming that it acted in good faith, in spite of all the evidence to the contrary. After carefully considering the testimony of South Carolina's state officials, who argued that they did not use racial data, the district court did not believe them due to a wide range of evidence. That plausible finding should be given deference. In addition, the majority invented a new rule of evidence by drawing an adverse inference against the challengers for not submitting an alternative map, even though they presented much other proof. Nowhere else in our equal protection law have we forced plaintiffs to submit one particular form of proof. Why should this area be different?
No, the district court clearly erred in siding with the challengers on the racial gerrymandering claim. The challengers also raised a vote dilution claim, which rested on the same findings of fact and reasoning. Because those findings were clearly erroneous, a remand of the vote dilution portion of the case is appropriate. We reverse the judgment of the district court in part and remand the case in part for further proceedings consistent with this opinion.
You rule, Supreme Court.
You suck, Supreme Court.